and empowerment of women is still a far cry. Miss Jessica, granddaughter of a female freedom fighter, Srimati Raksha Devi, has been a flag bearer of women's rights. She has led the movement for entry of women into the religious institutions and the fight to decriminalize adultery. This further contributed to her popularity and presence among people, and very soon she became the first woman leader of opposition in parliament. In a country where high constitutional offices have been only held by men, she has organized various campaigns to further the cause of women empowerment and bring about gender equality in the society. Even after 7.5 decades of independence in this country, एक औरत का अपने ही शरीर पर क्यों कोई अधिकार नहीं है? एक औरत अपने ही वैवाहिक जीवन में अपनों के द्वारा शोषित की जाती है। ऐसे तमाम कार्यों को हम अपनी सामाजिक और सांस्कृतिक पर्दे से ढक रहे हैं, संविधान के साथ खिलवाड़ कर रहे हैं। This is the right time to put an end to the suffering and violence inflicted upon married women. This bill shall criminalize non-consensual sexual intercourse within a wedlock.
ये बिल कुछ नहीं बस एक माध्यम है जो हम पुरुषों को कुछ भी करने के लिए बनाया गया है। मैं और मेरी पार्टी इस बिल की कड़ी निंदा करते हैं।
To the dismay of Miss Jessica, the bill was not passed in the parliament, and Miss Jessica then approached the High Court, challenging the constitutional validity of Exception 2 of Section 375 of the Eloria Penal Code 1860.
The impugned provision is constitutionally valid, and the sole purpose of criminalizing such an act belongs to the domain of the parliament, and thus this appeal is rejected.
इस पर की बड़ी खबर ये आ रही है कि आजकल चर्चा में रहने वाली जेसिका जी की अपील हाईकोर्ट ने खारिज कर दी है। तो आइए आप लोगों को ले चलते हैं हमारे संवाददाता राजीव कुमार जी के पास, जो इस समय हाईकोर्ट के बाहर मौजूद हैं।
धन्यवाद अंजलि। जैसे आप सभी जानते हैं, जेसिका जी के अपील को हाईकोर्ट ने खारिज कर दिया गया। आइए जानते हैं रूलिंग पार्टी के नेता का इसमें क्या कहना है।
हमें तो पता ही था यही होना है। हम हाईकोर्ट के फैसले से बिल्कुल सहमत हैं। हमें ये बिल हमारी मानसिकता के बिल्कुल विपरीत लगा था, तभी हमने इसका पार्लियामेंट में भी विरोध करा गया था।
जेसिका जी, आपका इस मुद्दे पे क्या कहना है?
देखिए, ये संघर्ष अभी समाप्त नहीं हुआ है। मैं हाईकोर्ट के फैसले के विरुद्ध हूँ। मैं सर्वोच्च न्यायालय में स्पेशल लीव पिटीशन फाइल करूँ।
With general elections due next year, all political parties were getting up for the upcoming elections. Miss Jessica too started campaigning from city to city, and she became more vocal in her criticism of the government on this issue. Within a short period of time, Miss Jessica's popularity skyrocketed among the young voters, especially women voters. Everywhere she went for campaigning, she drew large crowds, to the extent of causing law and order issues at times. Many of her supporters called her as the last hope and the Iron Woman of Valoria. The polls conducted by various pollsters and news channels predicted that Miss Jessica had an upper hand over all her rivals, and she was being projected as the next Prime Minister of Valoria.
आज की रैली की सारी तैयारियां हो गई?
जी मैं पोस्टर्स बनवा दिए हैं, होर्डिंग्स लिखवा दिए हैं। अगर और कुछ रहता तो आप बता दीजिए।
नहीं बिल्कुल। याद रखना, आज का मेरा ये संदेश हर नारी के समझ पहुंचना चाहिए।
जी मैम, आप निश्चित रहिए, मैं सारे काम कर।
चलो।
1 2 3 4 जैसिका जी जयकार, 1 2 3 4 जैसिका जी जयकार।
Bodily autonomy is our birthright and we shall have it. Our rights cannot be sacrificed at the altar of cultural and religious practices. मौजूदा सरकार महिलाओं के प्रति अपनी विचारधारा में कोई परिवर्तन नहीं लाना चाहती। ये उनकी स्त्री दूषी मानसिकता को दर्शाता है। इन मौजूदा सत्ताधारी पुरुषों को ये बात याद होनी चाहिए कि जब एक औरत के सम्मान के साथ खिलवाड़ हुआ है, तब महाभारत छिड़ी है। अगर ये लोग अपने तौर तरीकों में कोई बदलाव नहीं लाना चाहते, तो ये समझ लें कि इनका भी वही अंजाम होगा जो कौरवों का हुआ था। जो पुरुष महिलाओं के अधिकारों के विरुद्ध है, वो ये याद रखें कि हम लड़ेंगे उनकी मानसिकता के खिलाफ, उनके विचारधारा के खिलाफ, उनकी तुष्टीकरण, उनकी राजनीति के खिलाफ। आप लोग ये बात याद रखें, आप अपने बहुमूल्य वोट उन्हीं को दें जो पुरुष और महिलाओं को समान अधिकार दे।
After this speech, there were massive protests in the country and multiple FIRs were registered all over the country under sections 504, 505 and 153A of the Eloria Penal Code 1860. Miss Jessica and her many supporters were detained on the grounds of breach of public order under the National Security. Miss Jessica termed the detention as a political persecution and stated that the government was abusing laws to go after her in order to halt the ongoing political campaign. A writ petition challenging the detention and for quashing the FIRs was also filed as she believed that prima facie no case was made out. The Supreme Court of the Republic of Eloria clubbed the writ petition and the special leave petition filed by Ms. Jessica against the judgment of the High Court.
Thank you, I believe. With that, judges, we will now give you a brief of the facts of the proposition.
Republic of Eloria hosts the world's largest population and is admired all over the globe for its democratic values. The Constitution grants the citizens of Republic of Eloria rights like equality, freedom of speech, and personal liberty. Republic of Eloria has been predominantly a male-dominated society. Women had played a crucial role in the freedom movement, but their role is not as highlighted and glorified as their male counterparts.
Moving forward, due to the prevalence of the very orthodox religious and cultural views, the participation of women in public affairs has been very low in this country. So the crime against women are very high. Equality and women empowerment are still a far cry in this country. Miss Jessica, who is the granddaughter of the freedom fighter Srimati Raksha Devi, is a champion of women's rights. She was elected as the first woman leader of the opposition in a nation where highly constitutional offices were occupied by men only. She has been a strong voice in raising major issues affecting women. Ms. Jessica had introduced a private member bill in the parliament which aimed at criminalizing the topic of marriage. But owing to the dogmatic and the non-progressive ideas, it could not pass.
Later on, Ms. Jessica approached the High Court challenging the constitutional validity of Exception 2 of Section 375 of the Eloria Penal Code 1860. A division bench of the High Court dismissed the petition. Ms. Jessica filed a special leave petition against the judgment in the Supreme Court of Eloria.
As the general elections were due the next year, Ms. Jessica started campaigning from city to city. She exasperated the government for its poor record on bringing about equality and women empowerment. Ms. Jessica's popularity had skyrocketed and many order issues and values. She had organized a rally on the eve of Independence Day, despite the government advising against holding that rally. In that rally, to the public, Ms. Jessica said in a speech that our rights cannot be sacrificed at the altar of cultural or religious practices. The government is oblivious to the helpless condition of the women and it only espouses a chauvinistic mentality. The men at the helm of power should remember that it was the women who stood up to the evil colonizers, and these people will be met with the same fate if they do not mend their ways. We will fight like hell for our rights. Men who seek to dominate and exploit us should remember that women will no longer remain silent and we will make you pay.
After this speech, there were massive protests all across the country. Many FIRs were filed against her under Section 504, 505, and 153A of the Eloria Penal Code 1860. Ms. Jessica and her many supporters were detained on the grounds of breach of public order under the National Security Act 1980. Ms. Jessica termed the detention as a political persecution and filed a writ petition in the Supreme Court of Eloria challenging the detention and for quashing the FIRs.
Now, the judges, the issues that are at hand in front of this honorable court are: 1. Whether the Supreme Court of Eloria has the jurisdiction to try this case. 2. Whether the exception of Section 375 of the Eloria Penal Code 1860 is violative of fundamental rights. 3. Whether the detention of Ms. Jessica under the National Security Act 1980 is legal. And the last issue, my judges, are: does there exist a prima facie case under Sections 504, 505, 153A of the Eloria Penal Code 1860 against Ms. Jessica?
So that is about the proposition of this. Now I will brief you about the final round elimination. There will be 60 minutes for each team to speak. No speaker can consume more than 35 minutes, so each speaker will speak only for 35 minutes. The team can divide the time duration of total 60 minutes according to themselves. And 5 minutes is reserved for rebuttal, which is included in the total time of 60 minutes. And any question answering now that is to be required is on the discretion of the bench, if the bench agrees. Any questions? Okay, so then we get started. I just call for the teams.
एक मिनट को बोलेंगे कि ये आप सेट करो कैसे करना है। ये रिमोट
There are some comment spiders within 28 minutes each. Only the single one shall be started.
The council. Effectively attend the pension This is council number 1 for the petition. Council 27 and will be dealing with the council. My co-council will be dealing with if my lords and members pass the case, council is permission to the argument with regards to petition 1. Issue of appointment. The Supreme Court of India has the jurisdiction to try the petitioner humbly submit that this honorable court has the requisite jurisdiction to hear the petitioner and the arguments will be submitted. Number 1, being that the petitioner has the sufficient notice and grounds to file a special petition under Article 126. And number 2, there has been a gross violation of fundamental rights because of which the petitioner has approached the honorable court and Article 2. My lords, with respect to the cross submission, the powers under Article 126 can be exercised against any judgment or order which is causing injustice to any party. And similarly, the power under Article 126 is unlimited. If my lords could refer to page 3 of the compendium, the same was held in the Durga. My lords, it is urgent to note that it confers the violation of the jurisdiction to entertain any order passed in any matter by any court at any stage of its proceeding, and its powers are generally limited, adjunctive, and unrestricted. The Supreme Court can use the powers under Article 136 to impart justice and remedy any injustice. The Supreme Court refers to over Article 136. I will try to case of N. Surikala. I also refer to the set of the compendium. It has been held that the Supreme Court can interfere with the judgment or order of any court of tribunal in its decision. In Government of Law versus State of Bihar, page 15 of the American laws, the Supreme Court has held that it is open to the Supreme Court to interfere with the findings of the High Court if the High Court has acted perversely or otherwise improperly. It is humbly submitted to this honorable court that there has been a serious miscarriage of justice caused by the dismissal of the matter by the High Court as elaborated in the issued for argument advanced petition. The council for petition humbly submit and request the honorable court to correct the same as the matter. Upholding the heinous offense of marriage and credit to be constitutional, even when it violates any cornerstone of the constitution, that is the principles of equality, human and individual autonomy, the failure of all constitutional consent. You were legislating to marital rape as an offense. So, the court decided that this is an offense because you don't see it as an offense as a crime. This is the court to decide whether it is an offense or not. So, you designate it as an offense. I can take it as an offense. Absolutely not. What is the council gave us? The council is trying to say by fixing the petition with respect to the right to utilize the matter. What is being done is a grave injustice because it violates the fundamental principles of our constitution, equality, equality, individual equality. And it's stated how the fundamental rights are stated equality, not how. Which like the council may further however, it is clear that the exception is finding the Article 14 because it is classification which Article 15 because it is a discrimination that is being made on government's marriage. Article 19 1A because there is a violation of a parent right to freedom of speech and expression by the ideology that by entering the marriage she is irrevocable consent to sex, and Article 21
being that there is violation of body integrity and
not absolute. That's the understanding. So that the restrictions are provided as a sanctuary. Article 21 is just kind of what is the procedure laid by the law? It's not just simply that no potential to for later, but in accordance with the procedure later. And the article 14 also, we have the only point we should remember it is not absolute. That point we have to keep in mind.
while Article 99 are not absolutely rigid and state can impose restrictions, present grounds for managing this exception don't meet the requirements. The council could elaborate that further in issue 2. The council kindly proceed to issue 1. Much obliged. Therefore, in the present scenario, in the present specialty petition, there exists a substantial question of law that involves the interpretation of the Constitution, which has to be heard by the Supreme Court. In the case of Punjab and others, versus the state of Kerala and another, page 13 of the comparative bylaws, it was held that a petition seeking grant of special leave to appeal may be rejected for several reasons. These include if the petition is barred by time. Council, just a second. Please refer to the memorial page also where it referred to something that needed for us to have a look at it is to refer to the compendium. I can't see it. So, are you talking about the memorial or the compendium? Yes, we have submitted your compendium. The organized committee and members are. Okay, have you mentioned it in your memorial? Yes, madam. Please mention that which page number of the memorial. Or if you have an extra copy of the compendium, please go to bylaws. And also, if I could just take a minute. Yeah, yeah. Page number 16, paragraph number 7. My lords, as the council was stating, now there are certain grounds for which the petition seeking grant of special leave to appeal may be rejected. None of the grounds in the present situation are met. If my lords are satisfied with the submission, submission to respect to article. Your submission from the first statement is that there is a violation of fundamental rights. That's a submission from the first intention. My lord, the submission being made is with respect to Article 136 that there is a substantial question for, and we met all the grounds for this honorable court of justice. If my lord is satisfied after this submission, with respect to the second submission, there has been a gross violation of fundamental rights because of which the petitioner has approached this court under Article 32. The present writ instituted under Article 32 seeks a writ of habeas corpus to release the defendant, Miss Jessica, the first lady leader of the opposition in the parliament. Petitioner's fundamental rights have been undermined by her wrongful detention, even when there exists no prima facie case. These fundamental rights include the right to free fair trial under Article 21, right to equality under Article 40, and right to freedom of speech and expression under Article 91A, and right to assent peacefully under Article 91B. My co-counsel will further elaborate on the same. Furthermore, your lordships, in the case of Ram Singh versus Delhi, the Supreme Court has observed that it is our privilege and duty to see that rights which are intended to be fundamental are kept fundamental. Along the similar lines, in the case of Provesh Thakur versus State of Madras, the court has held that the Supreme Court is constituted the protector and guarantor of fundamental rights, and therefore it has the responsibility to entertain applications seeking protection against infringement of such rights. This depicts how, under no circumstance, can the Supreme Court deny any petition filed under Article 32 for issues pertaining to the fundamental rights of the citizen. By not entertaining the petition, the court would be depriving the petitioner of a fundamental right. Finally, my lords, the below rules with respect to the writ of habeas corpus have also been adhered to by the petitioner. The petitioner should be in the custody of another, the writ has to be filed by the detainee, and the writ cannot be successively made to different judges of the same court. In conclusion, my lords, it is submitted that the court has the requisite jurisdiction to hear courts, especially petition under Article 156 and the writ petition under Article 2. If my lords are satisfied, counsel information. Counsel for the petitioner submits that exception 2 of section 375 of the APC is unconstitutional as it violates articles 14, 15, 91A, 21, and lastly, it places an unconstitutional condition on the woman's rights to marry. My lords, with respect to the first submission, exception 2 is violative of article 14. The petitioner submits that the provision is violative as it creates an unreasonable classification and it defeats the purpose of law. My lords, with respect to this second exception, section 375 of the APC, there is a separate class of married women above the age of 15 years being created who are exempted from the purview of rape committed by their husbands. However, this was changed to the age of majority in the case of independent thought versus India, something that was also later reiterated by our Foundation. While the present position of the law applies to married women above the age of 18, the reasoning behind such classification still lies on the patriarchal assumption that when a woman marries, she implicitly provides irrevocable consent to sexual intercourse, echoing the stereotypical notion of non-agency of women. Furthermore, the requirement of marital rape to be committed on a wife having to be above the age of 18 faces a serious predicament as to why a woman loses the right to bodily integrity upon being 18 and wedded. Thereby, while the threshold of the age has been brought to the age of majority, the law still does not apply equality to women who are similarly circumstances. 2. It defeats the purpose of the law. Section 375 was enacted with an objective to protect women against sexual violence and safeguard their individual rights and dignity. As Justice Krishna has said, a murderer kills the body, whereas a rapist kills the soul, as was held in the case of Rafiq versus State of Bengal. Supreme Court has held in the case of State of Bengal, West Bengal versus Bangladesh, that any classification made as an Article 40 must be reasonable, there must be an intelligible differentia as well as a rational nexus. By not recognizing marital rape as a criminal offense, there is an explicit contradiction to the aim of the provision and the normalization of denying married women agency of their bodies. It is also pertinent to note that in some scenarios, women are legally and financially bound to their spouses, making it harder for them to seek help or assistance. By excluding such a vulnerable class of individuals from the purview of sexual crimes, the law fails to provide equal protection to them. Moreover, constitutionally, every female is equal to a male, and no subject can be interpreted or understood directly from this position. Therefore, the marital rape exception is not good as under Article 5. Council there is also Article 8, which talks about separation of powers. So something has to be implemented under the law is the law of the legislature. Why should the court prepare and amend a particular law? It is the law of the legislature. Legislature can do it if they feel that this is the need. So interference of the court in the matters of legislation will ultimately defeat Article 8. My lords, while there is the doctrine of separation of powers, we will also work on the system of checks and balances. We are not isolated to one type of parties. So there is a system of checks and balances. The court can review legislation and enactments and direct legislation. If my lord is satisfied.
Moreover, see that marriage is not a contract. Understand? It's a holy union between two minds. Therefore, there ought to be a flexible approach by both the parties. Therefore, you try to make it's not that married women stay in different individuals and unmarried women. That you understand. Because when there is a marriage, there's an understanding, they will together, immediate, even the adjustment. These things are paramount important. Keeping this in mind, and that is not a contract. That has to be kept in mind. Keeping in this background, what is your reaction on this?
Absolutely right, my lord. The council does not discuss that. By entering a contract of marriage,
It's not a contract, please understand. Marriage is not a contract. One should understand.
By entering into a marriage relationship, there are certain new legal rights and obligations that arise on the end of both the spouses. However, marriage cannot be used as a valid explanation to sanction violence or to sanction force. A man cannot forcibly commit the offense of rape on his wife just because it is his wife. That's what the council is like. My lord is happy.
Council, how do we decide whether there was consent or not? Because this could be, if we criminalize it, it could be used against the men on certain amount of law. It could be exploitation of men also. That is, so we have to think neutrally from both the perspective. How do we decide whether there was consent? Maybe there was consent and even say there was no consent. Then what does the board do in that situation?
Like my lord, but the state cannot be ability to prosecute effectively as a reason to not give victims, valid victims, legal recourse. Just because there is a probability of abuse of law, that is not a assumption enough reason to not give them legal recourse in the sense.
Has marital rape been recognized as an offense in any other country?
Yes, Your Lordships, in fact, if the council is right, almost around 150 countries, India has had policies. Cambodia happens to be one of the few countries that has not recognized marital rape as a offense, and that also stands contradictory to the position that India assumes with respect to international conventions, because India is signatory or not signatory to multiple conventions. So that's the elimination of this in the council. And so, the council please proceed. The next submission that the council will be making is that exemption 2 of section 375 is violated of Article 15. The argument advanced is that it discriminates on the grounds of age and marital status. As previously argued, the commission of marriage and rape not being recognized as an offense if the victim is married and above the age of majority is arbitrary and contributes to the subordination of a disadvantaged group of adult married women. The intersectional nature of sex discrimination does not operate in isolation from other identities such as age and marital status. Now, referring to Justice Chandrachud's anti-stereotyping principle as evolved in Nandesh's Johar, page 25 of the effective methods, it was that discrimination based on a stereotypical understanding of the role of sex would still be violated of Article 15(1). Exemption 2, that is a marital rape exemption, is only in furtherance of the Victorian doctrine of coverture that subordinates a woman's legal status upon being married. Her legal existence as an individual no longer exists, and as William Blackstone once famously said, by marriage, husband and wife are one person at heart, except now that the husband enjoys exclusive power over his wife, giving him immunity even from the legal offense of rape. A strong stereotype underlines this tension of control over women's sexuality stemming from patriarchal assumptions that the husband has the right to sex and the right to use his wife's body for this purpose. It reduces women to private property of sexual nature owned by distinct male owners. Ultimately, when individual dignity and freedom is being denied, not simply against the state, but also in social institutions and structures, the state must apply the Constitution to democratize private relationships and break down inequalities within those relationships. My lords, the third submission we're making is that the exemption is violated under Article 19(1)(a). A woman, by entering into matrimony, does not subjugate or subordinate herself to a spouse. It's not an irrevocable consent to sexual intercourse in all circumstances, as defined by Justice Shakti. Right under Article 19(1)(a) includes a woman's right to assert her sexual agency and autonomy. A woman has the right to withdraw her consent to sexual relations with her husband at any point. Not allowing her to do so would be violative of freedom of expression. Marital rape is this circumstance wherein a wife may say no to sexual intercourse.
It will create a situation where marriage couples may have to live with like this is the purpose of the marriage union, the holy marriage. Isn't that what you say? Let the marriage particularly the things are there. I don't think again the moreover, it is the legislature in their wisdom, they create this exception. Therefore, see, social life is equally important. Don't go by what is the legal right. More than that, the
agreed, my lord. While we do live in a civilized society, we also have to watch the fact that the interest of the state is not to preserve a deteriorated marriage. And when a husband is committing forcibly rape on his wife, that is one of the signs of deteriorated marriage. So why is the complaint stands testimony to that fact? So the interest of the state cannot be to preserve or not further break down such a traumatic relationship to say so. My lord, satisfied with the council, please.
I agree to whatever you say, but it's very difficult to prove that whether this particular habits of consent, it's very difficult to prove that within the marriage, whether there was a marital rape or not. And as my co-judges rightly pointed out, I think it will defeat the entire purpose of the institution of marriage. And see, the point is, again, if it's being exploited, 90% of it is being exploited and 10% of it is being utilized in a proper manner, then what about the 90% which is being exploited? Court also has to think about that, and maybe the legislation was not passed, and the High Court also has dismissed your petition. Maybe these are the grounds for it, that this has been dismissed. So if you had an international judgment, international, any other court has recognized this particular crime and stated a particular about it, please report that so that we are in a position to decide.
Yes, my lord. So if you look at People versus Liberta, my lord, do you have a copy of the comparative yet? So page 35 of People versus Liberta, what the council just reiterated about how the state has no interest in preserving a deteriorated marriage, and that one of the signs of such a marriage would be the wife taking apart marital rape. So that is something that is a court judgment which has upheld the marital rape. Marital rape as a defense, my lord.
It's your
Just a second, my lord. 1984. 84.
84 marital rape was recognized.
It was construed as offense.
Which country?
The United States of America.
Cultural values, but that culture may whether you should keep a country in our system or these things are not keep the application. It is able to the fact that the social life is very, very important. That so keeping this in mind, that just because country access does not mean that all other countries follow the suit. That type of argument is not acceptable. You know that the value systems and the European and American countries they are far ahead. That is what is ahead of them. Not always in all aspects of people. So voting this what you should be. Economic aspects one can, but the social is a very, very strong society. They live the social relationship. That is very, very important. That cannot be imposed. In particular, let us say marriage, the social integrity. That's most important. That does other than the society will be disintegrated. The marital life will become disintegrated. So that I think we should not move that and we should not take to the point that level that the marriage can be disintegrated. Rather than disintegrated.
What the council was again trying to put across to the bench was that it is also pertinent to note that while we do have our own social and cultural values, those values are ever changing. They're ever evolving with time with society. And now we agree that the whole intention was that match-up exceptions for the Victorian United, something that was in Elodia's colonial days. But we moved far past that, where the heartbreaker cry right now is for women empowerment, women equality. And match-up exception is not further that was my lord. That's what the council is doing. If my lords are satisfied, council.
I have a question first. As you know that the Dowry Act was framed to help the women poor. Has been misused so widely that the government is not thinking about some amendments. So, how do you see that? This law is passed. If it is misused or abused, then where are we going?
My lords, just because of the fact, again, as the council was previously mentioned, just because there is a possibility of cannot deny victims their right to be recourse. Their fundamental rights are being violated. As you said, in the case of Chandrima Das versus Gateway Board, the crime of rape is not just against women, but against society as a whole. It's a heinous offense because of the gravity in which it is committed. So when there is a victim of such an heinous offense, just because there is a possibility of misuse, we cannot be denying them any legal recourse. If my lords are satisfied with the counsel, thank you.
Reason is the number of cases reported immediately come to the immediately. Reason is the population. That population. What is the number of instances in not the general this cases. Only in the very few that was it's a taking the river is you are not between but if you go to the statistics, population crime committed. Insignificant. That's what
Agreed, my lords. Counsel will agree with that. Just bringing my lord's attention to the proposition as well. Wherein as per para 2, it does say that the Republic of Eloria is a patriarchal society where men constitute 47% of the total population. If you look at the social structure of Eloria, as in paragraph 3, female infanticide, girl child marriages, seclusion of women from public spaces are all commonplace, which is why there is a need to reflect such a case offense because there is a continuous discrimination that women are facing with respect to how they will in Eloria. If my lords are satisfied, counsel will move to the next function. Finally, my lords, with respect to Article 21, the petitioner submits that the marriage and rape exemption permits a husband to violate his wife's bodily integrity by allowing him to impregning her against her will be denied of her reproductive freedom. The exemption extinguishes a married woman's autonomy in one of the most personal and intimate of all human interactions. State would thus be violating the rights of every married woman by allowing their husband to rape them without fear of prosecution. Supreme Court has also recognized the sexual autonomy and reproductive choices of women as a component to their right to personal autonomy, as under Article 21. Every woman is also entitled to her sexual privacy, and it is not open to any and every person to violate her privacy as whenever they wish, as was said in the case of State of Maharashtra versus Madhya Pradesh. My lords, in conclusion, exemption 2 of Section 375 has been held in the Constitution. If my lords are satisfied, I could counsel the nomination.
The lordships, I shall be giving issues 3 and 4. Issue 3 being whether the detention of Ms. Jessica under the NSA is still allowed. The lordships, the present writ is being filed as Ms. Jessica has been wrongfully detained under the NSA of 1980, thereby directly violating her fundamental rights, that is, fair trial, personal liberty, the freedom of speech and expression, and to assemble peaceably, all of which the council shall argue upon. Your Honor, the NSA has its main objective as preventive detention, which can be inferred from its preamble. The concept of preventive detention is provided for the purposes of preventing a possible crime, and hence cannot be construed as a criminal conviction. It is humbly submitted that in the present case, the preventive detention law, that is the NSA of 1980, has been used as a tactic by the government to suppress the use of Ms. Jessica. This is evident as she has a fundamental right under Article 91A and 91E of the Constitution of Eloria for the freedom of speech and expression and freedom to assemble peacefully without arms. The speech which was so provided by the petitioner was in no manner a speech.
The previous article was that the people can also equally misuse. Not only you are alleging that it's a misuse. Same be done when the freedom is given to the married woman. That is not that you cannot include that.
Much right, Lordship, that is a pertinent question. What my co-counsel was trying to argue is that it is an indication of a very amateur judicial system. Not recognize something like marital rape without due test in place.
He was taking part of the judiciary calling us immature is not acceptable. So
My apologies.
please take care of that.
My apologies, Lordship. What the council was really saying is that the country as a whole is moving in a particular direction wherein we are upholding a few more changes in the judiciary. The council by no means meant to disrespect the judiciary. My sincere sympathies. If the council were to come,
So also keep in your mind, there is the same country has come on to the list of that is the one kind of the reservation, but we will have to be in the political argument. That's what don't take only one particular, take a holistic view. How the government is working on particular. So it's not that you have to take a holistic view. What is how the government is moving. In fact, we will agree that this country has done far more than any other country with regard to the protection of the government. That's also we have the country as the national commission for women. Systems are being created to take care of protection also. So take the holistic, but not only this one particular that we will have.
Your Lordships, the speech which was so provided by the petitioner in no manner was a speech to inflict public disorder. This can be inferred from the fact that the speech was based upon actual data, highlighting the condition of women and how they were oppressed by the society. Yes,
When we're talking about facts, first page, last point, while addressing a rally on the eve of independence, that despite the government advising against the rally, who started the rally, then as a result of this rally, next paragraph, after the speech, there was a massive protest all across the country. So you want something law and order of the country. What else do you expect from the government?
much right, Lordships. The council is here speaking, which is your Lordships. The permission, however, was given by the government for the same rally. Yes, your Lordships. The same was clarified upon the interpretation of the Moot proposition in the email provided for the same.
That is not required to the judges.
This was a clarificatory clause which was given much Your Lordship, right? Your Lordship, it is pertinent to note that Article 19 clause 2 provides for reasonable restrictions, but it can only be raised indicated such as public order. Your Lordship, in the landmark judgment of Ram versus State of Bihar, it was held that public order, if disturbed, must lead to public disorder, and every breach of peace does not lead to public disorder. Your Lordship, the court in this particular landmark judgment explained the difference between law and order, public order, and national security by diagrammatically explaining via three concentric circles, where it explained the scope of all three of these, where it made that a very narrow interpretation must be based upon curtailing of speech, and it said that they are moving towards this idea where rights are held in the pedestal rather than in restriction. Right now, the respondent, Ms. Jessica being held and her rights are being curtailed. It is something that is going beyond the scope of what the other things calling public disorder.
Ms. Jessica, your mind, is it a political or personal vendetta side as the proposition elections are also coming? So is it a political vendetta or is it genuinely about right?
Of course, not Your Lordship, as state, she is the granddaughter of one of the most famous freedom fighters, Srimati Raksha Devi, and she's been the black hair of female equality, even when she did not have any form of political, any form of much Your Lordship,
One thing is about the freedom of speech. Freedom of speech and everything. But instigate others to come in mind. That is the point of your citizenship. You have the right to speak, but you have no right not to speak. That has to be in mind. That's because you have a right and you get others. You should not instigate others to come in your mind. Everybody can come in. Then to come in violence is why we have speech. It's happening and it will happen. So the right to speak should be very careful. That has to be careful.
Your Lordship, the council will deal with this particular matter in detail in its report as well as the answer any questions. Your Lordship, it is also submitted that Article 19 and Article 21 include the right to personal liberty, which was also filed for Ms. Jessica under the detention made in accordance with the NC of 1980. It is pertinent to note that judicial review under Article 21 expands to include executive action, very much within its ambit. Your Lordship, currently the current position of law with respect to reading fundamental rights together was first discussed in Eco Part of India, which was a six-judge bench, which was overruled by our Supreme Court that is a 11-judge bench, 10-judge bench, respectively. Wherein it said fundamental rights can be read together, which is that to accomplish the other point. Your Lordship, it was very neat to grant Ahmed Patel versus State of Gujarat and others that prevented detention with a serious invasion of one's personal liberty and the normal method of a open door person charged with commission of any offense to disprove the charge or to prove his innocence that is right and not available. Lordship, it's been noted in the case at hand. The petition has been filed in order to prove how there is an absence of absolute proof. And further state to prove beyond a reasonable doubt that the acts of the Jessica invoke these grounds. Your Lordship, if your Lordship has actually the petition of the commission being detention, that's right, Lordship. The next is that your Lordship, the grounds provided under Section 3 of the Act are not applicable and have not been proved by the government beyond a reasonable doubt. Your Lordship, it is submitted that the grounds under Section 3 and 4 of the NCA, particularly 3 clause 1 clause 8, subclause 8 and 3 subclause 2, are in direct relation to the violation of public order and security of the state. It is essential to emphasize upon the very recent judgment of this very honorable court of Amina Begum versus State of Telangana. You can go to page 40 of the compendium, where you see that tests were laid down to examine the legality of the orders of preventive detention. Your Lordship, the 10th order has not been able to be fulfilled, and it is only submitted to the honorable court that it is based upon probative value as the acts of the judge on the basis of the detention made has not been established by the government beyond a reasonable doubt. Furthermore, the reason that has been so provided by the government is merely the rally which was conducted by Ms. Jessica, which came out construed as approximately the court in case of Ram Loya also laid down that there must be a cogent intimate relationship between the statements that have been made and the statement that are being made. This is not enough proximate cause to prove the same. Your Lordship, to only exercise the rights under Article
Where does religious practice come? And religion is something very sacred, very value start talking about religious practices, it is obviously going to disturb the law and order of the country. So when one is speaking, you should be mindful of what you're speaking. There is no need of religious practices being talked about as cultural or religious practices, like our rights cannot be sacrificed on the basis of cultural and religious practices. This is all provocation.
Understood. However, Ms. Jessica was merely remarking upon how certain traditions And this can be construed as an actual situation of the state of the country at the time.
And only said that the rights have to be so when you're talking about right to freedom of speech and expression, there is also freedom of religion. That also has to be read together. You can't just isolate one right and not think about the other right.
If you have the right to speak, I have the right not to get. There are two rights. One is the positive right, and the negative right. If you invoke for your right to speak, I will invoke my negative right not to get. That is also significant. That means that you cannot speak. It is not relevant for the other person. You cannot keep on speaking rubbish in the public transport. That's what there is other person right, negative right. Right not to get. What the law doesn't for the speaking. That is also part of the right. That is so speaking while exercising your freedom of right, very, very careful. Not only for each and every freedom to not be able to create. One thing, it is a extraordinary careful about it. You have right to move. You are not able to right move. By vote, you have right to move. That's also very, very careful. While the right
Your lordships, in the case of S. Rangarajan versus B. Jagjivan, both stated that the anticipated danger should not be removed, conjectural or far-fetched. It should have a proximate and direct nexus to the expression. The expression of thought should be so intrinsically dangerous to public interests. Or in other words, the expression should be so inseparably locked up with the action contemplated, like the equivalent of a spark in a powder keg. Your lordships, it is respectfully submitted that these statements should not be taken out of context by handpicking few sentences here or there. Upon a complete reading of the passage, the general idea that Ms. Jessica was really trying to share with respect to how women have been subjugated since years and how certain rights, contextual taking of sentences may appear that she was perhaps maybe making a speech that was slightly divisive in nature against men and women. However, the general meaning that the speech was trying to make out was with respect to how women's rights need to be placed at somewhat of a pedestal considering the
When one voting and that, you should also try and understand that there will be uneducated people also coming over there. They're not just the educated class who will understand what is the intent behind it. They will not do so. Yourself are saying that there are certain words that are spoken and that should not be considered. You should see the general intent to it. But then in rally, you can't discriminate between the people and you can't say that the person should perceive my intention was this, my intention was not this. What kind of people come to the rally? I don't like this argument.
much obliged. Much obliged, Your Lordship, to answer your question with respect to the uneducated class of people having it, how the reasonable anticipation could have been placed on Jessica. Your Lordship, to clarify, the recent judgment of Jodh Singh versus State of Uttar Pradesh states that mere intolerance of people is not reason enough to hold someone criminally liable for something that they are saying or doing. Because just because a society or a particular group of people have reacted violently to something you are saying is not evidence enough that your statements have merit for being criminally liable. Your Lordship. State Jodh Singh versus State of Uttar Pradesh. Much
The researcher can tell us.
Much obliged. Much obliged. Your Lordship, in the case of Vinita Rattaraya Samanth versus the Commissioner of Police, Thane and others, the court set aside an order of detention and stated that on perusal of the various grounds and incidents annexed there, it is difficult to find any material or basis on which the detaining authority could have come to the conclusion that the detainee had encouraged his followers or could have given active support in their violent criminal activities, and therefore the court stated that the detention cannot be sustained. Moreover, Your Lordships, in the recent case of Dr. Kafir Khan, the petitioner was detained under the NSA for addressing a gathering of students who were protesting. The Allahabad High Court stated that the detention is illegal and held that what remains is a mere apprehension expressed by the detaining authority without supporting material which apprehension can be founded. The
allowed judgment that you're quoting in front of the Supreme Court, knowing that this right judgment, what is the binding fact of such judgments?
Your Lordships, I was just about to mention that the Supreme Court reiterated the same view in the Kafir Khan case.
How many judges bench?
I will take up much pleasure, Lordships. Your Lordships, there have been no instances in the factual matrix which provides about the grounds being supported to the advisory report. This is an essential because Section 11 of the Act of the Court provides an opportunity for the detainee for the court. Considering the above arguments, it is only submitted for this honorable court that the writ of habeas corpus must be allowed and maintained in order to uphold the fundamental rights of Ms. Jessica, which have been enshrined under the Constitution of Victoria, and to provide justice in accordance with the same. If your Lordships are satisfied with the current issue, now the Commission will move to issue 4.
Two questions asked by me. If your researcher would come up in the rebuttal round and answer.
No, Your Lordships. The first thing that the Council would like to argue on Your Lordships is with respect to the grounds on which the Supreme Court can quash the FIR and how they have been fulfilled. Firstly, Your Lordships, there is a lack of prima facie case. If upon preliminary examination of the allegations and evidence, the court finds that there is sufficient or insufficient or no credible evidence to support the charge made in the FIR, it may quash the FIR. The same was held in Ramesh Chandra Gupta versus State of 2B. Secondly, Your Lordships, there is a violation of a fundamental right. If the FIR or the actions of the investigating agencies violate the fundamental rights of the accused, the Supreme Court may quash the FIR. The same was held in the case of Ashwini Kumar Patil versus Union of India, in which a lawyer was accused of offences under 500 and 501 of the APC for allegedly making defamatory statements against Supreme Court judges. Your Lordships, the petitioner filed a petition to the Supreme Court seeking to quash the FIR, arguing that the FIR was an attempt to stifle his freedom of speech and expression and rights guaranteed under 19A of the Constitution of India. The Supreme Court quashed the FIR, exercising his freedom to write and expression. Lastly, Your Lordships, the FIR is based on frivolous and unsubstantiated grounds. As the allegation that patently false and fabricated, the court may quash the FIR, and this was held in the case of Zakira Habibullah versus State of Gujarat, wherein a petitioner, a social activist, was accused of offences 153A, 500, and 5 clause 2, in which the petitioner filed a petition to the Supreme Court seeking to quash the FIR. The petitioner argued that the FIR was frivolous and vexatious, and the Supreme Court allowed for the petition to be quashed, allowed for the FIR to be quashed. Lordships, if your Lordships is satisfied with the grounds on which the FIR can be quashed, I would Commission to move to proving that the ingredients of Section 504 have not been satisfied. Much obliged, Lordships. Your Lordships, it is most humbly submitted that the prerequisites for criminal liability of Section 504 are firstly that the insult must be such as is likely to provoke intentional insult of a person. Secondly, insult must be
Read the first one.
yes. There must be intentional insult of a person. There must be
Likely. Is that a word like?
yes. The insult must be such as is likely.
Like, just focus on the word likely and then
Much like your logics in any one of these ingredients are not satisfied. The accused cannot be said to have committed an offense under section 5.
The problem that you cannot cover likely versus the problem outcome can also be covered.
That is one of the ingredients. Agreed. The first ingredient, your logics, that is insult, meaning treating a person with offensive disrespect or offer indignity. And such an insult may be caused by spoken or written words and may be in the form of speech or writing. It is a well-established principle that statement, as such, does not constitute an insult unless it is impregnated with malicious intent. No persuasive grounds exist to substantiate the notion that the petitioner harbored any intent to cause offense. Ms. Jessica was merely remarking upon the factual situation of the country and sharing her opinion in good faith. Mere intolerance of protesters cannot be grounds for Ms. Jessica to be held criminally liable for such a harmless act. The nature of her remarks stemmed from a realistic state of affairs and in the country, and no anticipation on her part would have led her to believe that the statement would lead to breach of public peace. Her speech cannot be considered an offense under section 504 of the APC because her speech was critical of the government and its policy, but it did not advocate for violence, hatred, or go against any individual or a group.
Violence, but the words that way definitely you could have to say it's violence, definitely necessary. One need not advocate violence, but the words are such those that
And come to you yourself as read this thing, and there were certain words that were spoken, and that may not have been violence according to you, but then we have seen that.
they don't go with the regular, like people are. Sometimes they're more emotional. Actually, that's my feeling such a once you very, very extraordinary by selecting the person.
Much like three logics. However, for these ingredients to be proven, if any one of them is missing, that means it is a direct breach of the fundamental right of speech and expression guarantee. Now, if the exact ingredient cannot be proven, that means if she's being held liable for something like this, wherein the burden is being placed upon Ms. Jessica for anticipating that society could have lashed out as to her statements, then that is unreasonable to the extent that it is restricting her own fundamental and inherent rights and logics. If the council is satisfied, the logics is satisfied, council is much like logics. The logics, it is humbly submitted that mere insult is not punishable under the aforesaid provision. It must also be proven that the insult was of such nature and provocation sufficed to induce breach of peace. Since it is already established that Ms. Jessica had not insulted anyone, no question of provocation arises. Ms. Jessica was making a women empowerment speech and condemning the hapless condition of women. Her words by no means can be said to be provoking. There must be an intentional insults in the form of words of conduct. If it is by words, the words must amount to something more than mere vulgarities, as was held in the case of Buddha's state. In the case of Abraham,
Once starting with the argument, in this, the first line of the argument was that since it has already been established, see, for the court to decide whether it has been established
apologies.
and not for the advocates to tell us that it has already established.
Apologies. The logics. What the council was really trying to do was drawing the link between my arguments. Much like logics in a complainant under section 504A of the APC, the complainant must mention the actual words which were used by the accused while insulting him or her. Otherwise, the court will not have enough material before it to conclude whether the words used by the accused amounted to intentional insult. Furthermore, the complainant must give out in the complaint that the accused intended or knew that insulting words were used by him which were likely to provoke the complainant in either to break the peace or to commit any other offense. Ms. Jessica states that she intends to bring about a sense of equality in the function of the state and made a speech prompting change for the better and not provoking with an intent to cause breach of peace. Your Lordships, the last ingredient with respect to statements being made to cause public breach of peace or any other offense. It is humbly submitted that there is no evidence to prove that Ms. Jessica's speech was intended to incite violence. Her speech was critical of the government's policies. And since it is already established, since the person insulting must intend or know it likely that such provocation will cause him to break peace or public peace or commit any other offense. Since Ms. Jessica was the granddaughter of a freedom fighter, that is Srimati Raksha Devi, she has been a flag bearer of women's rights and has led the movement of equality in the sense. No reasonable anticipation could have led her to believe that such a movement of equality and such a movement
All are equal before the law. Agree. Very important. The exploitation daughter, all those people, 86 and before the rights center, all are equal. That is very important.
Council's permission to wrap up his arguments. Much thanks, Your Lordships. Your Lordships, moving on to the last section 1A, Your Lordships, it is humbly submitted that the Honorable Court that the intention to cause disorder inside people to violence is a sign for law of this offense under section 153A of the APC, and the state must prove prima facie the existence of mens rea on the part of the accused, as laid down in Mandir Saeed Khan versus the state of Maharashtra. Prima facie, there exists no evidence pointing at Ms. Jessica's intent to cause prejudice to the maintenance of harmony among any groups, communities, or classes. Her speech had no element of intent to resort to violence such as arson, rioting, erosion of public services, etc. There must either be intention to promote such feelings, or such feelings should be promoted as a result of words spoken or written. Your Lordships, the words promote or tends to promote feelings of enmity can be read as denoting successful or unsuccessful attempts to promote the feelings of enmity. It must be the purpose or parts of the purpose of the accused to promote such feelings. And if it is no part of his purpose, the mere circumstance that there may be a tendency is not sufficient enough, as laid down in the case of Shrikant Shastri. Lastly, Your Lordships, there is no clear statement which can be pointed. Much thanks, Lordships. Therefore, in light of the issues raised, arguments advanced, and authorities cited, it is humbly requested that this honorable court adjudge and declare that one, the exception two of section 375 of the APC is not constitutional. The detention of Jessica under the National Security Act is not allowed, and for the habeas corpus should be allowed. And lastly, to quash and cancel the FIRs under section 504, 505, and 150A of the APC and pass any other order or direction as this court may deem fit, all of which is respectfully and humbly submitted. It's a pleasure arguing this court.
Greetings to the Honorable Court. The Council seeks permission to address the Honorable Bench collectively as your Lordships. Much obliged. Your Lordships, as we all know that this case pertains to two petitions, but the major fact that the Council would humbly like to point out in the petition, in the fact sheet, is that in para 14 of the fact sheet, if your Lordships may refer to, of the fact sheet. Your Lordship, for a reference, it is stated that the Supreme Court of the Republic of Aloria has snubbed the writ petition and the special leave petition filed by Ms. Jessica against the judgment of High Court. Your Lordship, it is a humble observation from the side of the Council that the court might have erred in clubbing two petitions because these two petitions arise out of different cause of action. Your Lordship, we know that the Supreme Court has ultimate power, but still it was a humble observation that the Council would like to point out. In argument, Your Lordships, We also humbly contend that the petitions are not maintainable. The first petition will be dealt by me, and the second petition, along with issues 3 and 4, will be dealt by my co-counsel simultaneously. If your lordships allow, the council would like to begin with that. Much obliged. The lordship, the first petition that has been filed by the petitioner Ms. Jessica is a special leave petition, and it has been filed under Article 136 of the Constitution of India. Article 136 empowers the Supreme Court to grant leave against appeal in any matter. Your lordship, but the main contention of the respondents is that this matter is not in the purview of the judiciary itself, because it would the matter of the exception 2 of section 375 would lead to a creation of new laws. For this, your lordship, I would like to quote the recent judgment of Supreme Chakrabarti versus Union of India 2023 that was delivered on 17th October. If your lordships may refer to the compendium from the side of the respondents, page number 2. Lordships, I will read. The lordships, the CJI very briefly mentioned that the existence of power of judicial review cannot be conflated in the manner in which the power is exercised. The exercise of power of judicial review abides by settled restraints which acknowledge that the power of law making is entrusted to democratically elected legislative bodies, and that the formulation and implementation of policy is entrusted to a government which is accountable to the legislature. Your lordships,
There have been n number of judgments, like Vishaka versus State of Pakistan, where the Supreme Court, where there was no law regarding sexual violence and workplace against women, the Supreme Court has taken cognizance. And then there are panel of orders like this, n number of cases where the Supreme Court has stated that if the judiciary is not able to, if the legislature is not able to perform its job, the judiciary will have to step into the shoes of the legislature and frame laws for it, because we want a civilized society at the end of it. And all three, as the counsel from the petitioner has pointed out, the checks and balances are also there. So, separation of power is something which is not something watertight or department may us.
Yes, your lordships. I understand the concern of my lordships, but your lordship, like mentioned, in the case of Vishaka versus State of Pakistan, these were separate guidelines when there was a void created in the ecosystem. But there are already existing remedies that have been present in the legislation.
Marital rape is not an offense. What are the remedies? It's not an offense.
Your lordship, it is regarding non-consensual sexual intercourse committed by a husband on his wife, for which the wife can approach under section 376 capital B if she is separated by. Moreover, under unnatural offences clause, that is under section 375 of the Union Penal Code. If she has been subjected to non-consensual sexual intercourse, there are other remedies available. Your lordship, this is the humble contention that it is a very normal contention that marital rape is not being recognized even in India. But it is after research done that marital rape is partially recognized in India by the virtue of section 376 capital B, where separated husbands can be charged under marital rape as an offense only.
But the
Your lordship, furthermore, that is why the council argued that non-consensual sexual intercourse by a husband or by any man or any woman, that includes the ambit of husband and wife, can be entertained by sections like 377, 354 capital A, outraging the modesty of women, and also under section 498 capital E, that is cruelty. Already existing remedies are present to the women, barring the legislation being classified as married women or unmarried women. These are already present for all women. So by removing the only safeguard that is presented for the husbands under 375 for exercising their conjugal rights, that has been provided. Moreover, your lordship, the petition that was the issue one, the petition is not maintainable as argued by the respondents under Article 136, because firstly, it is the work of the legislature, as I have already mentioned. Moreover, your lordship, it is not just that justice needs to be done because the act or the legislation is unconstitutional. Justice should not be just delivered; it should be seemed to be delivered. Your lordship, this is a complex matter. This is a very complicated matter, and declaring the exception was unconstitutional would not solve the issue of marital rape as an offense overall. There are practical difficulties, there are evidential matters in this second.
So we have kind of models, this section under the but that does not mean that the murders are not being committed. Having a section or having a provision does not mean that there would be an end to a crime, but at least it would have a deterrent effect. So that is the point.
Much obliged, Your Lordship. For this, again, the council would like to contend that there are other remedies that are applicable for the same act if done by the husband. Then there is no point to give it a term of rape just for the satisfaction of the petitioners or just for harming the ecosystem that has already been created by the legislative prudence. Your Lordship, it is contended that it is a legislative prudence where the legislature has criminalized non-consensual sexual intercourse without terming it as rape, just for protecting the right, not protecting only the spouses, but also the social impact on the family and progeny and all. Moreover, Your Lordship,
changing, keeps on changing. So, but when it was elected, what is the time passed between after that arrangement of this is now what the that to the passage in the time what the point there is a need for bringing changes in the also that is the question. You know what is the we are to
Your Lordship, to answer your question, it is humbly contended by the respondent that many amendments have also been made recently to the rape laws, including cruelty and section 377 unnatural offences, where again the woman has been given the right, by married women or unmarried women, the right to charge her husband if he tries to commit any non-consensual sexual intercourse. So why only the petitioners want to consider?
Just a second. What are the penal consequences? Offenses that you're talking about. What are the penal consequences? What is the punishment?
Your Lordship, it is
If it's a cruelty case, let's say you're not recognizing marital rape, and it's a case of cruelty, what is the punishment for it?
Your Lordship, it is imprisonment and if I may refer to this proper Your Lordship, for cruelty, that is 498 capital A. The punishment mentioned is lesser, I agree, than the 375 one.
Exactly the point.
Yes,
Exactly the point. That the punishment is such that the crime is a heinous crime, and the punishment that you were talking about is so less. So I don't think that this is a correct argument that already there is an existing provision. Because the punishment is very less.
Your Lordship, this is the humble attention of the respondents that even if the punishment is less, it is not that the married women are being totally deprived of the right to charge their husbands for committing non-consensual sexual intercourse. That the petitioners have contend that this exception should be declared unconstitutional because the fundamental rights are being violated. The respondents tried, Your Lordship, that firstly there is not even it is the matter is not even in the purview of the judiciary as mentioned in the recent judgment. It should be the work of the legislature, a humble contention from the respondent. Moreover, Your Lordship, for challenging its constitutional validity, the respondents would like to contend that it is not in violation of any of the basic fundamental rights guaranteed. Your Lordship, it creates an intelligible differentia under Article 14. In the penal code itself, there are relation-based laws made. There are age-based laws made where differential has been created between married women less than 18, married women less than 15, or for married women and unmarried women, or for relation-based laws. Moreover, Your Lordship, it is clear from this point that the differential between based on relation or marital status is not arbitrary or not discriminatory. It has been already been present in the penal section. Moreover, it is also stated in the case of Lily Thomas versus Union of India that to substantiate my argument that married and unmarried couples do not have the same status, and married couples have legal or
Lily Thomas, this is which year?
Your Lordship, it is
12, 2011, we are in 2023. Relevance of the judgment.
Your Lordship, it was just having a persuasive value that the contention of the respondent that I have already mentioned that relationship-based differentiation is valid, for which I have also quoted penal section of the.
Do you have any recent argument?
Your Lordship, in the case of Independent Corporations Union of India 2018, it was pertaining to the same matter, that is exception 2 of section 375, and it was clearly stated by the Honorable Justice Madan Lokar that the court has restricted their discussion to pertaining the age of the victim from 15 to 18, and the court clearly stated that the court cannot create any offense regarding the judgment regarding the exception of section 375. Moreover, Your Lordship, the respondent would like to humbly contend that it is again the legislative prudence, because even after the 172nd report of the Law Commission, 167th Parliamentary Standing Committee report, where there have been advices or suggestions made to the legislature to criminalize to declare it unconstitutional exception 2. The legislature has not done it because they believe that marital rape has partially been criminalized and sufficient remedies have been provided to the married women, so to which they can approach under different sections as I've already mentioned. Furthermore, Your Lordship, these are not just that justice can be written or delivered on a paper. These include many evidentiary difficulties, practical difficulties, to which the council would like to quote the case of Wahid Khan versus case of Adil Rajesh 2010. If the Lordship may refer to page number 3 of the compendium. Your Lordship, if the Lordship has, in this case, it was clearly observed that an offense of rape requires even the slightest degree of penetration, and the act is clear, stands established when such evidence appears in the medical reports. This was also stated in Santosh Kumar versus State of MP 2006. Your Lordship, these clearly show that even the slightest of penetration is the act is serious, and if that penetration is evident in the medical reports, it will clearly cause conviction of the husband. But these all symptoms are very common when people are in cohabitation. When a married couple is in the process of cohabitation, the penetration of the medical evidence is very easily achieved. Moreover, Your Lordship, if, as Your Lordships have already mentioned, if these are used by the vindictive or ulterior motive of the married woman, it will create a ruckus in the society. Because as the council had quoted NCRA reports in their memorial submission, written submissions also, this shows that mostly there are false cases that have been registered against men. Your Lordships, again, the respondents do not contend that just because of the practical difficulties of false cases, it should not be declared unconstitutional. Again, it should be linked with that already there are present remedies. Furthermore, it is mostly the part of the legislative action. Even if the court declares it unconstitutional, there will be a void created. That how to prove that marital rape has occurred, then the legislature could have to intervene in that matter. If eventually it is the matter of legislative prudence, then why? Yes. Much of that, Your Lordship, that is why the respondent never mentioned separation of powers. It is different in the case of exception 2 of section 375, because declaring it unconstitutional in itself will create a new offense, because it will include a different class that was not being referred to in that section. It will start including that class, and it will result in the creation of offense. And if not, then it will create a void, because there is no procedure standard that how marital rape can be proved in the court of law.
Counsel, but what do you have to say about the international position concept of marital rape, as the petitioners have pointed out that there are countries who have recognized this as an offense? So how do you answer that question?
Much of that, Your Lordship. To that, the council would like to answer that we contend that the exception of section 375 does not cast a right to submit herself irrevocably. Already mentioned, there are other remedies that have been present. Much of there are other remedies you are talking about that, but there are also laws also in our where the wife is below above 15 but below 18. What do you say about that? Because the laws are for minors in under POCSO Act, but being the marriage is not getting the benefit of it. What do you say? Much of that, Your Lordship. For that, also in the case of Independent Corporations Union of India, Under this exception, the married girl child between the age of 15 to 18 have been provided the safeguard under this exception. And for POXO also, as asked by your lordships, it is clearly mentioned that the submissions of the respondent pertain to, for just now, pertain to exception 2 of section 370. And as was earlier asked by your lordship that marital rape has been criminalized in different countries, we agree that it is time for Eluria also to make it an offense, but we only argue that it is the work of the legislature and it will be done. Your lordships, in the recent judgment of Supreme Chakravarti, same-sex marriage case, your lordships, it was the same matter. It can be put on the same pedestal that same-sex marriage have been legalized in different countries, but still the judges in their judgment quoted that the judiciary how much they might be sympathized by these arguments. They cannot eventually declare it because it will create a void in which legislature will have to intervene. It is not only about separation of powers and it is not only about violation of fundamental rights. It is a very complex matter that can only be handled by the legislature. The judiciary plays an important role, but it will not result in anything and it will create a void. That is the main humble contention of the respondent. Moreover, your lordships, the council would like to also mention that the clauses that have been mentioned in the rape law, that is A to D of section 375, one of the clause says that if a man rapes any woman on the pretext of being a husband, your lordship, this will also be in a contradiction. It itself says that if she has been raped, if she believes that the man is her husband, this is also, if exception 2 is removed, this will also become a contradiction. Then major changes need to be made to the legislature. It is also not about separation of powers. It is just that legislative prudence is the need of the hour in this matter, and the judiciary, if interferes, will make the matter more complex. Moreover, your lordship, it is final legislation is not passed. That is why you come to judiciary. Yes, your lordship, for the prudence of the judiciary also in the matter, because we have the separation. And equally, judiciary's opinion is also matter. Also required in the matter. That is why the petitioners have approached you and also the respondents are making this submission before you. The judiciary applied their mind and come to a conclusion that would be that would include legislative prudence and but just it is a humble contention that just by declaring it unconstitutional that the petitioners are asking for, it is assumed by the respondent as satisfaction of the key point. Judiciary is not there to satisfy anyone's scope. It is humbly let's not get into that. Your lordship on the line and noted was a humble petition. Moreover, your lordships, the council has no further submissions. The main submissions were that it is the work of the legislature and already. I agree with your point, your lordship, and that is why I think again with the point that if you today declare that constitution, it will create a void, and you will have to work as a watchdog again to give legislature the guidelines, and it will create a complexity in the matter. Much of that, your lordships, the council would like to now call upon the council to deal with the issue of the second petition, that is under Article 32 and the issue number 3.
Greetings to the honorable bench.
This is the council seeks permission to address the bench collectively as a much obligation. This is council on
Just an
behalf.
observation. Everybody's asking that you want to collectively as well as your lordship. Then there are three people sitting. Why can't you refer us as collectively as a ladyship? Just an observation.
Yes, sir. It will be taken into consideration by the council. It will be taken into consideration by the council. Much obligation. This is council on behalf of the respondents here to argue on the second part of the petition that has been filed by the petitioners under Article 32. That is for challenging the detention of Ms. Jessica under the National Security Act and for quashing of FIRs that has been filed under 6504, 505, and 153A of the Authority. Your Lordship, the arguments is presented to you in two bits, where the challenging of detention along with issue 3 will be read, and second leg, the matter of jurisdiction for quashing of FIR along with issue number 4. Your Lordship, it is humbly submitted before the Honorable Court that the petition is not maintainable under Article 32 because there is no violation of fundamental right and the detention stands. This will be proved by the following arguments. The preventive detention under the National Security Act and all the preventive detentions are protected under Article 22, Clause 3 of the Constitution. That says that nothing in Clause 1 and 2 shall apply to for any person who is arrested or detained under any law providing for preventive detention. Your Lordship, by virtue of these issues framed the moot problem, the council will be dealing with issue number 3, Simon release. Your Lordship, Section 3, Clause 2 of the National Security Act, reading from the bare provision itself, the council, the central government or the state government may, if satisfied, with respect to any person that, with a view of preventing him from acting in a manner prejudicial to the maintenance of public order or prejudicial to the maintenance of security of the state, can be detained under the section. Your Lordship, in the case, it is to be observed that it is only a preventive measure and not an action of arrest. Your Lordship, in the case of Nirappan versus District Collector and others, the purpose of the preventive detention is not to punish the person, but rather stop them from doing anything that can be harmful to the security of the state or maintenance of public order. Your Lordship,
Answer just a second. As the petitioners have pointed out, that there was a clarification issue according to which the permission for the rally was given. So everything was in accordance of law. Permission was given that Ms. Jessica was conducting the rally. So what is the problem?
Your Lordship, the problem here is the act committed and the consequences of the act, which created a problem for the authorities for maintaining the public order. The protest that has been there, not pertaining to a single locality, but nationwide, and multiple FIRs that have been filed, that has created a problem for the executive and the authorities.
There is a written that there was a problem of public order. It only says after the speech there was massive protest all across the country. Where is it?
Yes, sir. It is a matter that in the paragraph number 12, it is stated that straight after speech there were massive protests. And in addition, these protests were not pertaining to any single locality. These were nationwide protests, and there were multiple FIRs. In addition,
FIRs on the basis of breach of public order, but then it's written that there was a problem of public order.
in addition, we do not condemn that there was a problem of public order. We condemn that the National Security Act states that any act, if it is done, if it can be apprehended to cause a problem in maintaining public order, a person can be detained. That is what the humble submission of the council is. Much appreciated. In addition, that is why pertaining to the National Security Act, we state that an act was done and the consequences were the massive protests throughout the nation, by which there was a problem faced by the authorities for maintenance of public order. Because the authorities would have not waited for the breach of public order to happen further. The Lordships, in the case of Arjun Koshi versus State of Uttar Pradesh, it was stated that the anticipated behavior of a person based on the past conduct, in the light of the surrounding circumstances, may provide sufficient ground for preventive detention. And the sufficient ground and the anticipation was there because there was nationwide protests happening. If your lordships are conducted in the first argument, the council would like to move on with the second leg of the argument. Yes, sir. Yes, Your Lordship. Your Lordship, the National Security Act's objectives are stated. There are three objectives. That is, if any act is in any manner prejudicial to the maintenance of security of the state, maintenance of public order, and maintenance of supplies and services essential to the community. These three are the objectives, and our objective lies in maintenance of that is right. Your Lordship, moving on to the second leg of the argument. Your Lordship, the petition was also filed for the quashing of multiple FIR that has been registered throughout the country under Section 504, 505, and 153 of the Code. Your Lordship, quashing of FIR cannot take place under Article 32, first because there is no violation of fundamental right as such, because the council used to understand that how can filing of an FIR leads to breach of or violation of fundamental right of a person. Your Lordship, also there is also the petitioner. If also Your Lordships, if such petitions are entertained by the Honorable Supreme Court today, then tomorrow for every cognizable offence there will be petitions filed straight away with the Supreme Court for the and the essence of procedure established by law will completely be broken. Your Lordship, there are other provisions such as anticipatory bail that is provided in under the Code of Criminal Procedure under Section 483 that could have been approached. Also, the High Court could have been approached under Section 482 that the High Court has the inherent powers to entertain such matters for quashing of FIRs, because there is no such urgent matter for quashing of FIRs, and it is a total waste of time of the Supreme Court. Your Lordship, further, in the case of Arnab Ranjan Goswami versus Union of India, it was stated that it would not be appropriate for the court to exercise jurisdiction under Article 32 of the Constitution over the factors that are well within the ambit of the Code of Criminal Procedure, and the same was held in Gayatri Prasad versus Union of State of the British. Also, in the case of Rubilat Thakur versus Union of India, it was stated where the court ruled that the path of investigation should not be decided according to the whims and behests of the accused named in the FIR. Your Lordship, further.
Council, whenever you state it, please tell the youth that we can understand the relevance of that judgment in the present era. Is it reporting supposed to be 1960 judgment, then what is the relevance of that judgment?
Your leadership, for now, I would just say that these are the recent cases of Arnab Ranjan Goswami, also of Rubilat Thakur. Yes, sir. Your Lordship, it is also humbly submitted before the Honorable Court that there exists a prima facie case under the Section 504, 505, and 153 of the sections, and that is why we contend that there should be that petition should not be pushed. Your Lordship, Section 504 states that deals with the offence of intentional insult with intent to provoke. Provoke was breach of public peace. The legislative intent of this section is to protect the dignity and self-respect of an individual living in a room. The offence of insult spreads to a vast area of human being. In section.
So the intention plays a very important role. The petitioner was able to specify to intention has given permission to conduct the rally. So there was no intention that this would lead to such a protest. There was no intention. Basically, men's fear was missing.
precisely your relation that we just addressed in my further arguments. Your Lordship, in section 155 states that clauses B and C states that mention that words published, made or published with intent to cause fear, alarm, whereby a person may continues to commit an offense against the state, or words published with intent to incite any class, community, or person against the class, another class. Your Lordship, section 2 clause 2 also states that creating, promoting enmity, hatred between different classes of groups or any other class.
So the council, if the government has so much apprehension that such things will happen, because the fear of opposition also elections were coming, what was the need of it?
The leadership, these FIRs or multiple FIRs that have been filed, we are only pertaining to the question of washing of FIRs that should not be challenged, and which will be proved only by showing that there exists a prima facie case. There does not there exists a prima facie case to and this question of FIR should not take place in the Supreme Court. Further, leadership, we condemn that if your Lordship, insult is anything by which human feelings can be moved and public peace can be proved by words as well as deeds. It is an observation that was made in Chunni, King Emperor versus Chunni by Dayabai, and it was relied upon the landmark judgment of Bhimrao versus Venkatra. Also, in the same case of Bhimrao Venkatra, it was observed that the judging whether that insult offered by the accused is of such a character made by punishable under 504, the court merely is to consider that the state of ordinary for a reasonable man and see if the insult offered such if ordinarily sufficient to arouse passion and revoke retaliation by words. Your Lordship, it is to be noticed that even a single statement mentioned throughout the speech would have been provocative and insulting or hurting to the sentiments of the people. If you may refer to the fact sheets, paragraph number 11. Your Lordship, statements that our rights cannot be sacrificed at the altar of cultural and religious practices. Your Lordship, there are people of orthodox mentality and of modern mentality. You cannot impose a modernism on people who are of orthodox mentality, stating, hurting the people, saying that yes, sir.
If we were to talk about orthodox mentality, there was no need for child marriage act. There was no need for dowry act. This was there, but orthodox mentality is there at that time also, but still these acts were made. Still these offences were recognized. So we cannot rely just because there is an orthodox mentality, therefore the offence should not be recognized. That's not the point.
Yes, sir. But there were multiple statements that were made. Also, further moving further with my arguments, that men with the helm of power should remember that it was the women who stood up with the evil colonizers. These people will be met with the same fate if they do not build their ways. This is a clear bit of comparison between the evil colonizers that were there and the present men at the helm of power that have been inciting. It is hurtful to call to compare men of the society or the men who are at the helm of power to the evil colonizers. What are we trying to say here? That the men at the helm of power are curbing the rights of women as the evil colonizers did. Are we suppressing the rights of women as the evil colonizers did? Or will the actions be same by the women taken as if they were taken then by the evil against the evil colonizers? These are very hurtful statements, Your Lordship, that need to be considered today for convicting her under these sections of alluded period. Further, Your Lordship, I would like to cite two cases of one of which is Arun Khan versus State of Home Department, where the applicant in the submission replied upon the case of Balwant Singh versus State of Punjab. It was observed and held by the court only where written and spoken words have a tendency to incite violence and create public disorder. These provisions also relate to a tendency of provoking even in the slightest manner. It does not condemn that there needs to be an violation done or something like that. And conviction can be done mere on provocation also. That is why we condemn that there exists a very prima facie case which need to be investigated properly and thoroughly, and the FIR should not be paused. But this is the humble submission of the council and the council. Yes. And if your last continue, then my arguments are the council would like to further move on. Much obliged. Lordship, in the light of the facts stated, argument advanced in cases cited, it is most humbly prayed and implored before the Honorable Supreme Court of Appeal that it may be graciously pleased to adjust and declare that the petitions are not maintainable. The exception 2 of the section 375 of Valorem Penal Code is violative of fundamental right. The detention of Ms. Jessica under the National Security Act 1980 is illegal, and there exists a prima facie case under the sections of 504, 505, and 150 of Valorem Penal Code for which there should be a proper investigation. And for this, the court may pass any order that the Honorable Supreme Court may deem fit in the favor of the respondents to meet the ends of justice, equity, and good conscience. For this act of kindness, the respondent forever come to pay. Much obliged. Thank you for your kind attention.
Council seeks permission to move to the departments, which oblige and bishops. With respect to issue 2, my learned opposition counsel contended that there are various alternative remedies that can be approached. With respect to section 376B, it is only applicable to separated couples where they're living independently. With respect to 498A, it specifically talks about cruelty committed by husband against a wife, does not take into purview marriage and rape per se. 354, outraging of includes outraging of molested women, and sexual assault does not account for rape. Furthermore, account for rape as defined under section 375, which does involve an element of penetrative sexual assault. Furthermore, the Domestic Violence Act, as the bench had pointed out, the remedies provided under all of these measures are not proportionate to the crime that is being committed. When rape committed on any other ordinary woman who is not married is being treated with such severity, the same must be done for married women as well. Your Lordships, your Ladyships, again with the question of age of majority, why is it that upon turning 18 and being wed, that the right of bodily autonomy gets extinguished? Furthermore, my learned opposition had also stated about medical evidence. However, if the council would like to bring the court's attention to the fact that medical evidence is not the only evidence that is relied upon for conviction in the cases of rape. Through proper tests, definitive essentials, and proper regulations, the misuse of marital rape as also a law, as any other law in the history of evidence. Furthermore, the opposition had also stated the same-sex marriage. However, the council would like to bring the court's attention to the fact that the Supreme Court case was with respect to rights of marriage for same-sex couples. Marriage rape exception is an entirely different issue. And while the council also recognizes that legislative prudence must be exercised, the court also has a duty to judicially review such enactments as was enshrined in the presentation of the policy. And it is essential that the judiciary rules in a manner that does not violate basic features of the Constitution. And when rape is being committed, there are fundamental rights being violated that is essential to part of the Constitution. Your Lordship, your Ladyships, with respect to issue 3, as the learned bench had pointed out, it has been done on grounds of public order. However, there has been no cogent intimate connection, which was the test laid down in Ezra Viraj's case, that has been established by the opposition councils as well. While maintenance of public order is a ground under NSC, again, disruption of public order has not been regulated, either has the security of the state been established. Furthermore, with respect to issue 4, my learned opposition council had stated that the petitioners could have approached the High Court for quashing of such FIR. However, it has to be noted that there are multiple FIRs all across the country which were clumped together. Under 482, the High Court will only listen to quashing of FIRs with respect to its jurisdiction. Because there are multiple FIRs all across the country, it would not be able to exercise its jurisdiction. Finally, your Lordship's relationships with respect to orthodox mentality and modern mentality, these are all very subjective terms. There's no objective measure to say. What is hurtful and insulting is the fact that, as in Moot Proposition Para 2, along with men, many women have also played an indispensable role in the freedom movement, but their contribution to the freedom struggle and their role in post-independence activities is generally downplayed and not as much glorified as their male counterparts. It is in light of this fact that Ms. Jessica had mentioned about the evil colonizers and men who are at the helm of the bar. The state cannot pick and choose sentences that are convenient to prove their point without reading the entire context, as was argued by my co-counsel. Those are all the submissions, not just submissions. It was a pleasure and honor. Questions? Yes, Your Lordship. The Jodh Singh case was a High Court ruling, and Kapil Ram was a 25 case was a division bench. While the councils recognized that it's not binding, it is humbly submitted for using for the court's race.
Information preference and right. Lots of firstly pertaining to the alternative remedies, Your Lordship, it needs to be considered that marital rape is not the country when we are not even aware about marital rape and its consequences. There are types of marital rape, and we can in Hallelujah only talk about battery marital rape that is covered with violence, because penetration can be evident because of the cohabitation. So for that, basically, I was really referring to section 377 that punishes unnatural offences, and section 354 capital A, 298 capital A. These were for club when the penetration was processed from section 354 is coupled with violence. That was the reference from the side of the respondent. Moreover, Your Lordship, pertaining to issue 3, the proximate cause in itself is that parent will states after this speech there were massive protests. Your Lordship, it is just the molding of facts. The facts cannot be molded in such a way where it is mentioned that she had given a speech. After the speech, there were massive protests. It is very evident from the single line of Your Lordship that she was the proximate cause, that massive protests occurred throughout the country, and that would likely to cause disturbance and maintenance of public. Your Lordship, regarding to the question of FIR, Your Lordship agreed with the point of view of petitioner that under 482 CRPC, inherent power of the High Court is there. It is not that the High Court has the power to quash FIR, it is that quashing of FIR can be a part of rendering justice. But Your Lordship, but they could have approached to clubbing the FIR if they had inconvenience regarding multiple FIRs that have been filed. But directly asking for quashing of FIR where there exists a crime of case as humbly contended by my co-counsel is not an appropriate remedy before asking for the Supreme. That's what it was.
All right.
So by the time the judges are preparing the final score sheet, I request all the participants, all 4 teams and all the students of Amity Law School to assemble in the auditorium block B. This is downstairs, down floor, and we'll be commencing the valedictory ceremony in another 10-15 minutes. Okay, all are requested to go there directly to the auditorium. Your final attendance will mark there in the auditorium. Okay, thank you so much.
Edition 2023. The time has come, ladies and gentlemen, to draw a curtain to our program as we conclude this conference now. For now, I, on behalf of the entire university, express our gratitude towards all for making this event a successful event. We are immensely honored to have with us here today our esteemed guests, Professor Dr. Ankita Bali, Ministry of Commerce and Industries, Government of India, Ms. Manju Sehrawat, Vice President, Dwarka Court Bar Association, Professor Dr. K. Illumalai, Director of Law, Indira Gandhi National Open University, Mr. B.K. Ravi, DGP, Tamil Nadu, and Dr. Seema Kaul, Director, Institute of Constitutional and Parliamentary Studies, Lok Sabha. We are also honored to have the support of our very Honorable Vice Chancellor of Amity University, Haryana, Professor Dr. P.V. Sharma, and Pro Vice Chancellor of Amity University, Haryana, Dr. Vikas Madhukar, who have given us enormous support but could not join us today for certain reasons. We welcome you all dignitaries, and we are honored to have you with us today. And I would also like to invite Professor Dr. Ajay Kumar Bhatt, Director of Amity Law School, who's present here with us today.
शुभम करोति कल्याणम आरोग्यम धन संपदा शत्रु बुद्धि विनाशाय दीप ज्योति नमोस्ते. Saraswati Vandana is a prayer offered to Goddess Saraswati, who is regarded as the deity of knowledge, music, arts, wisdom, and learning. The prayer is chanted to seek the blessings of the goddess for success in academics, music, and any other creative pursuits. With that, I would also request our dignitaries, Dr. Ankita Bali, Ms. Manju Sehrawat, Professor Dr. K. Illumalai, Mr. B.K. Ravi, and Dr. Seema Kaul, along with Professor Dr. Ajay Kumar Bhatt, Director, Amity Law School, Dr. Pranshul Pathak, Coordinator, Amity Law School, Dr. Ankita Sharma, Assistant Professor, Amity Law School, and Ms. Neha Mishra, Assistant Professor, Amity Law School, to kindly come forward for lighting of the lamp, and I request the IT team to kindly play Saraswati Vandana.
We would first wait for our conveners to join. Please, Pathak sir, Neha ma'am, Ankita ma'am. Yes, I would also. Yes, I would also request our honorable semi-finals judges to please join us.
Kurutvang kalyanam arogyam कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः.
Can we have a huge round of applause?
शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः 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 शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः.
Thank you, dignitaries. Amity University, Gurugram is a part of Amity Universe and an innovation and research-oriented university, which strives to develop all-round personality of its students by making them not just excellent professionals, but also individuals with understanding and regard for human values. Amity University offers as many as 143 undergraduate and postgraduate and doctoral programs in diversified areas. These programs have been designed in keeping with the latest industry trends, which help the student discover new academic passions and thus attract a respectable number of international students as well. Amity University, Haryana has been awarded with the LEED Platinum certificate for being the best university in India and the second best in Asia, which has placed us on the global map by creating an environmentally friendly university. An environment-friendly campus amidst Aravali Hills, which are also known as the footsteps of Haryana, is indeed a step towards promoting environment-friendly values amongst us, and not only students and faculty members, but also the villages and areas that surround our university. At Amity Law School, the focus is on practical learning through real-life projects by providing a vibrant teaching faculty with sound knowledge on law and governance, and by frequently participating in and conducting national seminars, research publications, and moot court competitions. Amity Law School has always been engaged in sending its students to study abroad programs and in coordinating with leading law firms and governmental instruments for internship programs as well. To keep students abreast of the latest law developments, the curriculum is updated by industry advisory boards comprising of top law professionals, eminent judges, and jurists, which put emphasis on practical learning. Moving forward, students are also encouraged to visit different layers of existing judicial dispensation to acquire a first-hand introduction to legal issues, actual courtcraft, and the range of legal remedies available. Legal aids clinics are also held to prepare the students to know how to diagnose legal issues and suitable legal remedies apart from developing client interview techniques. Students also gain knowledge throughout workshops on jurisprudence by eminent legal experts.
Mooting is a specialized application of the art of persuasive advocacy and provides law students a valuable opportunity to own both their written and oral advocacy skills in the competitive field of litigation. Realizing the value of moot courts, the Moot Court Society of Amity Law School, Haryana, always works through the combined efforts of exceptionally competent faculty as well as the enthusiastic students and organizes various competitions to brush up the practical knowledge in the field of law in the students. The efforts of the society are channelized towards grooming the law students to make them fit for the legal world. It provides them with the opportunity to get trained at working in teams by giving different challenges in order to mold their attitude and personalities and prepare them to face life situations gracefully. Amity Law School has successfully organized 5 highly anticipated and prestigious national moot court competitions, which were inaugurated by the revered and esteemed dignitaries such as Honorable Shri Justice Deepak Mishra, former Chief Justice of India, and Honorable Shri Justice A.K. Patnaik, former Judge, Supreme Court of India, Lieutenant General Gurmeet Singh, Governor of Uttarakhand, and others. Furthermore, the valedictory ceremonies were chaired by distinguished and accomplished dignitaries such as Honorable Justice Swatantra Kumar, former Chairperson NGT, Shri Suresh Chandra, Information Commissioner of the Central Information Commission and former Law Secretary of the Government of India, Colonel R. Balasubramanian, former ASG, and Professor Balraj Chauhan, among others. This time, the organizing committee of the competition strives to successfully organize the 6th Amity National Moot Court Competition 2023. And this event is another milestone for the law school as well as the university. 6th Amity National Moot Court Competition is a simulation based on the leading issues emerging at the national level that are encountering rampant occurrence in today's world. The event aims to instill confidence in students and motivate them to overcome the ongoing crisis by exploring all the dimensions in the legal world. The competition confers a unique opportunity for the participants to understand the various conducts, procedures, and application of national law, along with the opportunity to hone courtroom manner and etiquette. Furthermore, we would also like to take this liberty to thank our knowledge partners, EBC and SCC Online, our education partner, Legal Bytes, and our sponsors, Pahuja Law Academy, Shivalik Housing, and Nihal Associates, who have supported our efforts to make this competition a success.
I would now like to invite Director of Amity Law School, Professor Dr. Ajay Kumar Bhatt, on the podium to deliver the opening marks for the ceremony.
A very good evening to one and all present here. On behalf of Founder, President Dr. Ashok Chauhan, Honorable Chancellor Dr. Aseem Chauhan, Honorable Vice Chancellor Professor P.V. Sharma, and Pro Vice Chancellor Dr. Vikas Matkar, I extend a very warm and cordial welcome to our honorable judges, esteemed dignitaries, and all the delegates of the sponsors institutions, and my dear participants, faculty members, to our 6th Amity Moot Court competition. It is indeed an honor to stand before you today and address this distinguished gathering. Today marks a significant milestone in the journey of our esteemed institution as we gather here to celebrate not only the rich history and the tradition of legal profession or legal education that the institution represents, but also the promise of an even brighter future. Amity Law School has always stood as a beacon of knowledge, a crucible of wisdom, and a training ground for the future legal luminaries. We are committed to fostering a culture of excellence, not just in terms of academic achievements, but also in the values that define a notable legal profession. The legacy of organizing moot court competition at our institution is a testament to our unwavering commitment to honing the legal skills and nurturing the talents of our future lawyers. Through the years, these competitions have become a cherished tradition, fostering an environment where students can showcase their legal acumen, advocacy skills, and critical thinking abilities. As we continue to build upon this legacy, we remain dedicated to preparing our students for the challenge of the legal world, ensuring that they carry forth the torch of excellence and uphold the noble ideals of our legal profession. I would like to take this opportunity to offer my congratulations to every participant for their active participation in this moot court. As we come towards the end of this competition, I would like to extend a word of advice to all the budding lawyers. Your journey through this institution will be demanding, but it will also be immensely rewarding. In closing, let us remember that the field of law is not just a profession. It is a calling to uphold justice, defend the rights of the oppressed, destitute, indigent, and vulnerable sections, and also to maintain the principle upon which our societies are built. I welcome and thanks each one of you for your presence here today and gracing this event. Thank you again, one and all. Thank you.
Thank you, sir. I would now move forward.
A word of special welcome is due to our esteemed guests today. I'm most delighted they have been able to accommodate this event in their very busy schedule of activities and that they have been able to come to officiate at this ceremony. We would therefore like to place on record a deep appreciation for the honor they have accorded us by agreeing to perform on this occasion.
I now request Professor Dr. Ajay Kumar Bhatt, Director, Amity Law School, and Dr. Pranshul Pathak, Coordinator, Amity Law School, to felicitate Ms. Ankita Bali, Ministry of Commerce and Industries, Government of India, by representing her with a memento and a sapling. So I invite sir to please come on stage. Can we have a huge round of applause? Furthermore, I would request sir to facilitate. To felicitate Ms. Manju Serawat, Vice President of Dwarka Bar Court Association.
I now request Dr. Pranshul Pathak, sir, to facilitate Mr. B.K. Ravi, former DGP Tamil Nadu, by presenting him with a memento and a sapling.
I would also like to call on stage our Professor S.K. Tripathi, sir. Please come on stage and felicitate our guests.
I now request Professor S.K. Tripathi, sir, to please facilitate Dr. K. Illumilai, Director of Law, Indira Gandhi National Open University. I now request our dignitaries to please facilitate Dr. Seema Kaul, Director, Institute of Constitutional and Parliamentary Studies, Lok Sabha. I now request our dignitaries to facilitate our judges for the semi-final rounds. May I now request Miss Pratibha Devi ma'am to please approach the stage. I request Dr. Ankita Sharma ma'am and Miss Neha Mishra ma'am to please facilitate our guests. I would now like to invite Mr. Santosh Kumar Tiwari sir on stage, please. Dr. Santosh Kumar Tiwari sir.
And the felicitation to Dr. Santosh Kumar Tripathi sir will be done by Dr. Santosh Kumar Tripathi sir.
Thank you, sir. I would now like to invite Mr. Arun Singh sir on stage for the felicitation. Can we have a huge round of applause for our guests, please? Thank you, sir. I would now request Mr. Navid Bansal sir to please approach the stage. Thank you, sir. Thank you, ma'am.
Okay, moving forward. Ms. Ankita Bali is an accomplished professional with extensive experience in the field of international policy and affairs. She completed her post-graduation from National Law University, Bhopal, and since then worked in the Ministry of Commerce and Industries, Government of India. Her expertise lies in the areas of constitution and administrative law, along with international trade and trade policies. Throughout her career, Ms. Bali has participated in numerous national and international conferences, where she has represented the country and shared her knowledge and expertise with the international diaspora. She has also been a keynote speaker at various international seminars where she has delivered insightful talks on a wide range of topics related to constitution, administrative law, international trade, and policy. So now I would like to request ma'am to please address the gathering.
Good evening, everyone. First of all, congratulations to Amity Law School for organizing such a beautiful event, to all the faculty members who have been a part of it, and for treating us very nicely throughout the event. So thank you so much. And no event, I suppose, is complete without the applause of the students. So please, a huge round of applause for all the students, the transport committee, the conveners, everyone who was involved in the event. So very well done, and just keep going on. Just a few suggestions for all the mooters and speakers who were there. Please quote the citation whenever you're quoting a judgment. So that's very important. Try to use languages which are more respectful towards the court, like few words I pointed out. So take care of it. This is a learning experience for you also, and please don't hate us for grilling you that much, because we just wanted
to grill you so that you learn from this competition and move ahead. So congratulations to all the participants who participated, and I hope they're going to announce the results soon. So congratulations in advance to the winning team. So just a huge round of applause for Amity as well. Thank you so much for inviting. Thank you.
Thank you so much, ma'am. I think we are really used to it now. So moving forward, Miss Manju Sehrawat, who's an advocate, passed out from Maharishi Dayanand University, Rohtak in the year of 2006. She has been handling matters relating to cheating, white-collar crimes, property disputes, commercial disputes, matrimonial disputes, cases related to sexual harassment at workplace, cases involving heinous crimes like rape, POXO, dacoity, murder, etc. Presently, she is Vice President of Dwarka Court Bar Association and also the former Vice Chairman of Coordination Committee of all District Courts of Delhi, and has remained the Lady Member Executive of DCBA in 2016 to 18. We welcome you, ma'am, and we request you to kindly address the gathering. Let's have a huge round of applause.
गुड इवनिंग टू ऑल प्रेजेंट हियर। सबसे पहले तो मुझे यहाँ से बोलने का मौका दिया और एक मूट कोर्ट को प्रिजाइड करने का मुझे मौका दिया, उसके लिए मैं फैकल्टी और स्टूडेंट्स का बहुत धन्यवाद देती हूँ। ये जो इस तरह की जो मूट कोर्ट्स हैं वो हमें एक सीखने का, स्टूडेंट्स को सीखने का एक वो प्लेटफॉर्म देती हैं जहाँ पे एक लर्निंग होती है जो हमें थ्रू आउट लाइफ हम इस प्रोफेशन को, लॉ के प्रोफेशन को चाहे किसी भी रूप में हम अपनाएं, जुडिशियल ऑफिसर्स के रूप में, एडवोकेट के रूप में या किसी और भी, ये जो लर्निंग है, जो एक अंडरस्टैंडिंग एक टॉपिक की होती है, हाउ टू प्रेजेंट, हाउ टू स्पीक, हाउ टू अंडरस्टैंड दी थिंग्स, दीज आर वेरी इंपॉर्टेंट, वेरी वेरी इंपॉर्टेंट। और ये बहुत अच्छा है कि आप लोगों को ये मौका मिल रहा है और आज भले ही आप ये फील ना करो बट आने वाले टाइम में आप फील करोगे कि जो अंडरस्टैंडिंग आपने किसी टॉपिक को सीख के की ड्यूरिंग योर स्टूडेंट लाइफ वो कितना पे करती है। आप इससे बहुत कुछ आगे जाओगे, बहुत कुछ सीखोगे और ये एक पहली सीढ़ी है इस जीवन में आगे चलने की लॉ के फील्ड में। तो आई कॉन्ग्रेचुलेट ऑल ऑफ देम और दोनों ही टीम्स ने बहुत अच्छा किया और आप लोगों की मेहनत बिल्कुल साफ नजर आ रही थी कि आप लोगों ने बहुत इसमें अपना एफर्ट्स डाले हैं। और इन चीज़ों को लेके मैं दो लाइनें आपको ज़रूर सुनाऊंगी जो बड़ी खूबसूरत लाइनें हैं, क्योंकि इस फील्ड में या तो मूट कोर्ट लगा लो या आप आगे अगर एडवोकेसी में आते तो हार जीत दो चीज़ें होती हैं हमेशा और दोनों ही साथ चलती हैं। तो किसी ने बहुत अच्छा कहा है कि कोशिश नाकाम हुई तो क्या, जिद तो मंजिल पाने की है। कोशिश नाकाम हुई तो क्या, जिद तो मंजिल पाने की है। राहों में मुश्किलें बिखरी तो क्या, बात शिद्दत से मुकाम चाहने की है। तो हार जीत, कम मार्क्स, ज्यादा मार्क्स तो एक एस्पेक्ट है, असली बात ये है कि आपने कितनी मेहनत से उसको किया। तो आई कॉन्ग्रेचुलेट बोथ द टीम्स एंड ऑल अदर स्टूडेंट्स फॉर देयर ब्राइट फ्यूचर। ऑल द वेरी बेस्ट। थैंक यू।
Thank you so much, ma'am. Very rightly said by you. Ladies and gentlemen, distinguished guests, it is an honor to extend a warm welcome to the stage luminary in the legal arena, Dr. K. Elumalai, a seasoned legal professional. Dr. Elumalai brings over 4 decades of unparalleled experience, having practiced before the Supreme Court of India and the High Court of Delhi since May 2022. His illustrious career is marked by a profound commitment to the field of law, economics, and banking and finance. A scholar of exceptional merit, Dr. Elumalai holds a PhD in law, a Master of Law from the University of Delhi, and extensive qualifications in economics. His academic journey is crowned by a rich tapestry of achievements, including a doctorate that critically studied the Consumer Protection Act with a focus on banking services. Not confined to the courtroom, ladies and gentlemen, he has also left an indelible mark as a professor and director at the School of Law in Moot, New Delhi, and at VAMNI Pune. His service extends to economic roles at Punjab National Bank and academic positions at renowned institutions as well. I kindly request her to please address this gathering.
respected dignitaries on the dais and of the dais, and the beloved students. Today, when I came here, I was recollecting my own student days. I must congratulate Amity Law University, Gurgaon, for selecting such a topic which 30 to 40 years back would not have been thought of. I was seeing in my mind when I was sitting in this evaluation process, mind was going on how these young students, 18 to 20 perhaps, or 22, talking about marital rape. I mean, it's thanks to the university for selecting such a topic which was nobody had the courage to discuss this type of topics, at least 30 to 40 is number one. And the students, I mean, without getting in the wedlock, how they seriously took the subject matter with courage, confidence, bold, and speaking on these about various pros and cons of this, really, it's amazing. And for the students also, and just a few advices as a person putting out a 4 years of decade experience, particularly law students. See, you select whatever the profession you want, in the sense you want to go to judiciary or advocacy. But one thing you should remember, man, you should be very, very be sure in your goal. Set your goal and move towards that goal, and your work out this target, some sub target, so that you can achieve your goal. Somebody, whatever many things are there. Today we see at the Supreme Court the judges, advocates are being promoted as a judges, but they are not accessing the position. Reasons are very many. There is a dearth of judges. I mean, people are not coming forward to occupy the position of the judges. So my suggestion will be, please do enter the judicial profession also, write the exams and all. Come, you can as a law student contribute to the society in very many ways. As a judges, you can give very good judgments to the society. As an advocate, you can change the society at large and all. Or if you go to the corporate world, any other ones and all, really you are a long way to go. You can shape the society, contribute to the society. More than that, what is your satisfaction? That is very, very important. Another thing, what you learned in this 5 years, going to learn whatever things are there, that is nothing. The real learning starts when you step out to the college or the institute concerned. Real struggle, real life starts there only. When I got my first degree in MA economics, I was putting this question myself: am I become master in economic subject? Because economics has that 30 to 40 disciplines. I studied only 5 disciplines. How I can treat myself as economics? Put yourself law. Holding a PhD degree in law, I'm a doctorate in law. How many laws are passed by this country? Runs into thousands. How many laws I'm having the knowledge? It's a practical. You think it that way. Don't get to the study is. It's a. I won't say it's a license. It is an as a qualification that you acquire, but that may not take you to other strides. And also for that, you have to work very hard, have a goals and work with and all. And very flourishing. I wish you all flourish in your profession, whatever it's called, and contribute to the society. That is very, very important. I bless you, one of all, that you should live a very peaceful life in your career and all. Do something to the society. That's all I want to say. Thank you very much, please.
Thank you so much, sir. Ladies and gentlemen, we are honored to extend a very warm welcome to a distinguished leader amongst us, Braj Kishore Ravi, who is an IPS officer whose remarkable journey embodies a fusion of professional excellence and unwavering dedication to social causes. As a seasoned police officer, Mr. Ravi has not only represented India in the United Nations peacekeeping force, but has also specialized in security, contributing significantly to the formulation of policies for vital installations and corporate entities. His role as an advisor for the Indian Oil Corporation stands a testament to his strategic acumen in enhancing corporate security. As we welcome him to our stage, let us acknowledge not just the accomplished police officer he is, but also the compassionate social reformer whose leadership has left an indelible mark on the realms of security, governance, and community upliftment. I would now like to request Sir to address the gathering.
Good evening to all of you. And let me start that when I got a call from this law faculty of MIT, I was surprised that why a police officer has been called for this moot court. Well, when I started my career and I joined police, so at that time, as a person, I was having a conflict between the 5 P's. That a person who has become a police officer has to deal with the one, public, second, press, third, prosecutor, and fourth, politicians. So I had seen the press. I have dealt with them, prosecutors also, but I never got a chance to sit in the judge's seat and then see how the proceedings are being held. So thank you for calling me here, and I was enriched by your performance. I will also, quote, you must be knowing Mr. Sidhu, the cricketer. Once upon a time when the Indian Test team was not doing well, he phrased his thoughts, which you must learn. He says that it is always better to prevent and prepare than repent and repair. Now, this can be fitted into everyone's life. It is always better to prevent and prepare yourself than to repent and repair. Now, as far as your career is concerned, you have to think that what is your goal? And once the goal is clear, I think you will find the path. And I had seen your performances, the petitioner and the respondent, and the reaction from the judge's side. It was quite enriching for me, and I wish you all the best in coming future. No, somebody said that I am DGP. No, I have just taken VRS last month and will be joining politics so that I can have all the peace in my pocket. Thank you very much. All the best.
Thank you so much, sir. Dr. Seema Kaul is a highly experienced and accomplished professional with an illustrious career in the Lok Sabha Secretariat. She joined Lok Sabha Secretariat in the year of 1992, and after completing more than 31 years of dedicated service, she retired from the post of Director, Parliamentary Research and Training Institute for Democracy. During her tenure as Director in Parliamentary Research, has honed her expertise in handling a wide range of training programs. Currently, she is serving as a Director in the Institute of Constitutional and Parliamentary Studies. Beyond her contributions within the Lok Sabha Secretariat, Dr. Seema Kaul has taught in Delhi University colleges as well, from where she herself acquired her Master's, MPhil, and PhD degrees. I request ma'am to please address this gathering with her wise words.
Good evening to all. First of all, I would like to congratulate Amity Law College for organizing this moot court in a very, very graceful way. And I also congratulate them for choosing this very, very bold subject. And at the last, I would like to appreciate the efforts put by the participants. They have shown their team spirit. They have shown the knowledge of law, and the way and with the poise with which they have taken the grilling shows that they are the budding lawyers. And all the best to you for your future endeavors, and all the best to students also. And maybe you will one day will be seen in some court or in some law firm. So thank you so much.
Thank you so much, ma'am. I will now move further and request our dignitaries to please be present to give the mementos to our sponsors. So I request Dr. Pranshul Pathak sir and all the other dignitaries to please felicitate the sponsors today. So I would now like to request to present the memento to our knowledge partners EBC and SCC Online, and our education partner Legal Bytes.
On behalf of SCC Online, I would request Om Srivastav to collect their felicitation. And on behalf of Legal Bytes, I would request Deepak Bishnoi. I would now request members from Pahuja Law Academy to please approach the stage.
I think they've left. We'll move forward.
From Shivalik Housekeeping Services, I request Vipul Kaushik to please approach the stage.
Can we have a huge round of applause for our sponsors? Without their support, it would have been impossible for us to organize this competition.
From Nihal Associates, I request Mr. Vinayak Haritesh to please collect their memento.
Let's keep giving them a huge applause, audience. The time has come for the declaration of the results presented in this competition now. May we request our honorable guests on the dais as well, our semi-finalist judges also to come on stage as we present the certificates and the further awards. Okay, so first we have our semi-finalist teams. We have team code 116 Asian Law College.
And the team members are Nabila, Adya Kishore, and Pranjal Gupta.
Congratulations, guys, to make it to semi-final rounds.
And our semi-finalists will be getting 1 year of Legal Bytes subscription.
I would now like to call our second semi-finalist team, team code 121, Vivekanand Institute of Professional Studies.
And the team members are Kashish Agarwal, Vasudev Thakur, and Tanya Kumari.
Now I would like to call on stage our best draftsman, Mr. Mehul Saini, who is also a pass out from our college, our alumni.
Please give him a big round of applause.
Now moving forward, best memorial has been backed by team code 116, Asian Law College. Let's give them a huge round of applause.
And the members of TC 116 are again Nabila, Adya Kishore, and Pranjal Gupta.
I would now like to call on stage our best researcher, which is from team code 121, WIPS, Tanya Kumari.
I would like to inform the audience that the best draftsman will be getting 5,000 rupees as cash prize and Legal Bytes yearly subscription. And the best researcher will also be getting 5,000 rupees of cash prize.
Now moving forward to our best motor, which has been backed by team code 105, Shruti Satish Kumar, Christ University. I would also like to announce that she will also be getting a cash prize of rupees 5,000. Congratulations to all the teams. Okay, now the most awaited time has come for the runner-up and the winner. So I would take this honor and invite Dr. Pranshul Pathak to please announce the runner-up and winner. Okay, any guesses till then? Audience watched the final round. What do you think? So, who thinks that which team is going to win? Okay, let's see. Let's see.
Okay. So it's a democratic guess, and the judgment is same. The runners-up are Lloyd Law College, TC 120, and the team is of Ishita Arora, Anay Singh, and Ayushi Shrivastava. Congratulations, students.
I would also like to announce that the runner-ups will get rupees 15,000 cash prize and an yearly subscription of Legal Bites.
And I proudly announce the name of winning team for the 6th Amity National Moot Court Competition. And the team is Christ University, comprising of Srishti, Ashwin, and Taru. Congratulations, guys.
And they would also get a cash prize of rupees 25,000 and an yearly subscription of Legal Bites. A huge round of applause once again for the winners, runner-ups, and all other teams who have won something. Now I would like to, 1 minute dignitaries, I would request you to please, we also have to give awards to our organizing committee. Okay, so I would first like to invite on stage our student coordinators, Mr. Vinayak Haritesh and Mr. Vipul Kaushik, to receive their certificates and making this event a huge success. Please come on stage. Let's give them a huge round of applause.
Furthermore, I would request our co-convener, Ms. Riya Radhakrishnan, to please collect her certificate. And now I would request our student conveners for this ceremony, Ms. Ananya Gaur and Vanshika Jain. Now I request the faculty conveners for this ceremony, Dr. Pranshul Pathak, Dr. Ankita Sharma, and Miss Neha Mishra.
Let's give a huge round of applause for our faculty conveners. Without their support, I don't think we would have made this a possible event. Let's keep applauding for our faculty conveners. Thank you so much, dignitaries. Now you all can sit. Okay, moving forward, before concluding with this ceremony, I would request everyone to get ready for an insider's view of the legal arena. As the 6th Amity National Moot Court competition unfolds, we invite you to witness the stories, strategies, and sheer determination that laid the foundation for this spectacular event. So let's go beyond the case files and dive into the heart of this competition. I would now like to request the IT team to play the BTS video. I would like to request Srinivas sir to please play the BTS video. Okay, so I think technical glitches are part of a life now. Can we check the sound, please? Our very precious Srinivas sir has now approached the IT works. So I'm really sorry, guys, for the inconvenience. Yes, he's there now.
I've been trying to call. I've been on my own for long enough. Maybe you can show me how to love. Maybe I'm going through a drought. You don't even have to do too much. You can turn me on with just a touch, baby. I look around since city's cold and empty. No one's around to judge me. I can see clearly when you're gone. And I said, ooh, I'm blinded by the lights. No, I can't sleep until I feel your touch. I said, ooh, I'm drowning in the night. Oh, when I'm like this, you're the one I just, hey, hey, hey. I'm running out of time, 'cause I can see the sun light up the sky. So I hit the road in overdrive, baby. Oh, the city's cold and empty. No one's around to judge me. I can see clearly.
Thank you. Thank you, IT team. I would now like to kindly request our student convener of 6th Amity National Moot Court Competition, Ms. Vanshika Jain, to present the vote of thanks.
Faith is taking the first step even when you don't see the whole staircase. With these words of Martin Luther King, I, Vanshika Jain, student convener of the 6th Amity National Moot Court Competition 2023, take this honor to draw the curtain to this competition. Before that, I would like to extend a heartfelt gratitude to the esteemed judges who spared their precious time for gracing this event with their utmost presence. I would also like to thank our sponsors, SEC Online, EBC, Legal Bites, Pahuja Law Academy, Shivalik Services, and Nihal Associates for supporting us throughout the event. Amity Law School started organizing moot court competitions in the year 2016 with the first national moot court competition. And since then, Amity Law School has been a flag bearer for successfully organizing 5 highly prestigious national moot court competitions on constitutional and criminal laws. Amity Law School is proud to announce that with this event, we have added another feather to our cap by organizing 6th Amity National Moot Court Competition 2023 with the participation from 30 teams such as Christ University Bangalore, KLE Law College, SRM Sonipat, LPU, Voxen University, IP University, GD Goenka, Lloyd Law College, Vips University, and Asian Law College. Finally, the top teams, Christ University and Lloyd College, battled for the winning trophy with their argument and oratory skills and were judged by a dynamic and elite panel of judges. I would also like to thank various participants who have dedicated their valuable time and efforts for this competition. We would further like to extend our gratitude to our respected Director of Amity Law School, Dr. Ajay Kumar Bhatt, who has always stood like a pillar and has radiated his guiding light upon us. We would also like to thank our faculty conveners, Mr. Pranshul Pathak, Dr. Ankita Sharma, and Ms. Neha Mishra for bringing this event to the path of success. This event is incomplete without the immense hard work and dedication that has been displayed by convener Ananya Gaur, co-convener Riya Radhakrishnan, and student coordinators Vinayak Haritesh, Vipul Kaushik, and our organizing committee, which includes Deepak Kumar Bishnoi, Nancy Gujjar, Chirag Saini, Mukesh Godara, Ayushman Pandey, Shivam Singh, Khushi Agarwal, Priya Agarwal, Palak Bansal, Om, Sarthak, Arsh Dubey, Anika Jolly, Rashi Sharma, Mahir, Kashish, Divyanshi, Kushagr, and our IT team Prakash, Vansh, and Pratham Singh, and many more. With this, we come to an end to our 6th Amity National Moot Court Competition 2023, as we hope and aim to continue with this legacy of organizing moot court competitions. Thank you, everyone.
Thank you. We all can disperse now. But before that,
it's our endeavor to always learn from our past mistakes. So every year, sir, after valedictory, we are, unable to take the group photograph. So may I request the winning team and runner-up please to come on the stage for a group photograph. All the semi-final judges, the faculty members, faculty conveners, and the student conveners, can you all please assemble here? Dr. Ankita, Neha, Ananya, Vanshika, Riya Radhakrishnan, all the student organizing body, Vinayak, Vipul, can we have you on the stage? Om, all the LOs, can we all assemble here?
both the teams also, I would request you, the runner-up and the winner, to come one by one. First, we'll have the runner-ups with your trophies. Please come on stage. We'll have a group photograph.
Oh, okay, the idea is that thank you, sir, for this advice, and this is first time happening. This modus operandi is adopted first time, sir. Students can stand there. आप नीचे खड़े हो जाइए and then you can take this.